Your ex is threatening to take the kids away from you because you started a new relationship and they're going to go to court. Can they do that? Yes. Are they going to win? Depends. Let me explain Michigan law so that you can determine the risk and be prepared. If there's an existing court case, either parent can file a motion to change custody, establish custody, change parenting time. You can't prevent someone from filing a motion. The next step, though, is to determine whether or not they're going to win that motion. And if you're going to seek a change in custody, you have to establish whether or not there's an established custodial environment. And then you're going to have to, as a threshold issue, prove that there's a change in circumstances or proper cause. If your ex prevails on that step, then they're able to go on and have a custody trial or an evidentiary hearing. When a parent files for divorce, for example, there's that extra hurdle of finding whether or not there's an established custodial environment isn't normally part of the equation, but there is going to become one the longer the case takes. During a custody trial, the judge will review the 11 best interest factors to determine which parent should receive custody of the kids. Those best interest factors are at MCL 722.23. One of these factors, factor E, requires the judge to review the permanence as a family unit of the existing or proposed custodial home or homes. What does that really mean? Factor D, in the previous video, the judge is reviewing whether or not your home was acceptable, whether or not you moved, and whether or not your home was stable, and whether or not you intended to continue in the same locale. In this factor, the judge is going to look at your family unit and the relationships in the family. Stay with me. By the end of this video, you'll know the difference between D and E. And you'll also know the evidence that you're going to need to provide and 5 essential steps that you can take right now to strengthen your case. I can share with you also a couple of real-life cases that show how judges apply this factor in court. Factor E asks the court to evaluate the permanence as a family unit of the existing or proposed custodial home or homes. That means the court wants to know, is your home life stable? Is it consistent, and will it continue to provide the support, the emotional support that your child needs? Big picture, the judge is going to do a deep dive into your relationships. They're going to look at your previous relationships. They're going to look at your current relationships. And they're going to look at your kids' siblings. If you've got step siblings, half siblings, are they getting along with them? Are they bonding? They're going to look at relationships with significant others. Are you doing well with the new stepmom or the new stepdad? What's their relationship? Who's caring for the children? Is it going to be daycare? Is it completely different daycares and changes of daycare? Those are all things that the judge is going to look at. For example, if you've got grandparents involved with this who've always provided care, you've got a component of stability. So, the first step to preparing for Factor E is understanding the kind of evidence that judges are going to review in order to assess that stability and permanence of your family unit. The judge is going to want to see that you have been and will continue to reside in the same place with the same people. You can provide evidence of that by saying, look, I'm in the same home with the same people. You're going to show that you're financially stable. Again, there's not issues of people coming and going and you're supporting them. And there's a lot of different changes in life about expenses and whatnot. The judge is going to want to know, how are your kids doing with everybody in the family unit? How do they get along with step siblings? Do they do activities together? You're going to be able to show that. How are the kids involved with their community and with their school? All of these things show continuity, stability, permanence. For example, teachers, coaches, neighbors can all testify about how your kids are getting along with everybody else. One very important factor is that you should focus on the permanence of the home, not necessarily the acceptability. For example, there's an old 1996 case where the Court of Appeals reviewed a trial custody decision. The father was living with his parents and the mother was living in university housing, attending the University of Michigan. The trial court ruled that the parents were equal on 10 best interest factors, but that the dad won on this factor because the grandma was providing daycare and the child being at dad's house was somehow better than living and getting the university daycare. This was a single parent attending an academic program, and the trial court didn't like that. The Court of Appeals overruled that and said, no, we're not going to just simply have that one factor influence this. And so there was a family unit of mom and the child that had the stability that the Court of Appeals was looking for. Document your housing stability. Give a strong case that this is the best place for your child, that they're getting along with everybody in the home, that there aren't frequent changes, and you can prevail on this step. Hopefully this information helps you and it makes you more prepared. Until next time.